And to be clear, Your Honor, my client did fill out previously an advice of rights form that I
equate that with riding lawnmowers.
Right, go ahead. I'm sorry, Your Honor. My client did previously fill out an advice of rights form, but I re-reviewed that with him. And he knows that he previously filled out a sentencing judge waiver, but he also knows I've reviewed that with him as well. Please write it in, please.
All right. The plea form in this case indicates that the defendant will be pleading to 3 charges. That he will be pleading to the possession of a firearm under the influence, the actual stated count 3, as well as an addition, and that's the 93-day misdemeanor. He will be pleading also to operating while visibly impaired first, a 93-day misdemeanor. And will be pleading to attempted possession of a loaded firearm in a motor vehicle. And I believe that's a 1 year.
That is a 1 year, Your Honor, and I do believe mandatory forfeiture is a component of the offenses the defendant will be pleading to as well.
That's 1 year. Fines on that are
1,000?
Yeah, I think so. I think that's right. All right. And then counts 1 and 2 would be dismissed. And
the people are agreeing at the time of sentencing not to
no upfront jail if defendant remains compliant.
Correct.
Okay. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name.
Elliot Kazan.
All right, sir. It is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
All right. First charge is a stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court costs if you were using and or discharging the firearm. Also mandatory forfeiture of the weapon or device. You understand that?
Yes, Your Honor.
All right. Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired first offense. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could order rehabilitative services or any community service support deems necessary. Court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Also, count 5 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration of 1,000.
It's easy to talk about justice when it's theoretical, harder when it's personal. The closer the case hits the home, the more we realize how fragile fairness really is.
$1 fine plus court costs. You understand that? And also mandatory forfeiture of the device. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form previously, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No. Your
You're
Honor.
doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
June 22nd, 2023, at the location of Jackson Road near Stabler Road, Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much, if you recall?
5 to 6 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police,
Why'd they stop you?
rolling through a stop sign.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the station or hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
.095 blood alcohol level.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
In that motor vehicle that you were driving, did you have a firearm in it?
Yes, Your Honor.
And where was it?
In the glove box.
All right. And did you have authority to carry that firearm in that fashion in there?
No, Your Honor.
And I think that's and at the time you were under the influence and you had possession of that firearm.
Yes, Your Honor.
Counsel?
Was the firearm loaded?
No, Your Honor.
Well, actually, what?
Yes,
It actually.
Okay.
Yeah,
Was the
yes, ma'am.
firearm loaded?
yes, I had, yes.
All right.
In the magazine, not the chamber.
Yes. In the magazine, not the chamber. Yes.
But nevertheless, that constitutes.
Yeah. Same, yeah.
All right. Now, counsel, have I complied with the court rule?
I'm satisfied, Your Honor. Thank you.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be. We're on the wrong thing. Yeah. Give me that sentencing date again.
June 16th.
Sentencing, June 16, 2025, 9 a.m. Fresh hour. All right, Esteban.
Your Honor, we are requesting the court reinstate my client's bond. His original bond was 5,000, personal recognizance 5,000. He was ordered to community corrections to participate in sober link testing. The last time we were here, we offered to switch from that to a scram tether. That's our request, is to reinstate bond with the scram alcohol tether.
Anything from the people?
Your Honor, the people's concern is that the defendant not be consuming, so a scram tether will accomplish that goal this time.
I'll reinstate the defendant's previous bond condition. So he set his bond $5,000 personal recognizance bond. The defendant is to be placed on a scram tether prior to his release. I will sign that order, and I know you're trying to work through that, so we'll sign it and make sure that it gets over there.
Thank you very much, Your Honor.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court does call the case People versus James Sharp.
James Fifelski, appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Glenn Sharp, Your Honor.
Thank you, sir. What are we doing?
Your Honor, we're asking the court to set this for preliminary examination. Mr. Sharp does have sentencing on a federal case on June 17th. We'd ask the court to set it for the 24th.
Is all discovery complete?
Yes, Your Honor.
Would the people have their witnesses available on the 24th? Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you very much, Your Honor.
We'll continue. Thank you. Court calls case People versus Sterling Paris.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Sterling Paris.
Your name, sir?
Starling Paris.
Thank you.
Your Honor, may we-
Okay.
You can't hide emotion in a courtroom. It leaks. In a voice crack, a clenched jaw, a nervous laugh. The transcript won't record it, but everyone watching will remember it forever.
Complaint.
Oh, but can you come talk to me?
All right. Thank you.
I have other cases in here.
Court calls the case, People versus Jody Williams.
Ready, Your Honor.
Alexander, on behalf of the people, Your Honor.
You're just everywhere.
Pardon?
You're everywhere.
It's been tough. I'll get my steps in. Joe Simon on behalf of Ms. Williams. Jody, state your name.
Jody Williams.
Thank you.
Your Honor, we're asking the matter be set for preliminary exam. And because you always know I never cause trouble for the court, what is the earliest possible? Because my travel dates are both on successive Tuesdays. I'd like to have this sooner than the 24th if possible. I travel on the 24th and then on July 1st. So
Oh, so you want us to accommodate your scheduling
if
on
possible,
everything?
if possible.
That's an arrogance I haven't seen in a long time. Will the 17th work for you?
Yes,
All right. So
thank you.
discovery is complete.
Yes.
Would the people have their witnesses available the 17th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, June 17th, 2025. 9 a.m. That is before
Judge Moore.
Judge Moore.
Wait for me outside, okay? Thank you. Oh, sorry.
Bond will continue. Thank you.
Thank you, Your Honor.
Bye.
I'll see you on the next docket on Zoom, but Your Honor, I will say this, it's always an uplifting experience.
Back at you. That's all I got. Court calls the case, People versus Wesley Brand.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell on behalf of Mr. Wesley Yonder Brand.
All right. What are we doing? I think I have a conditional release
They're gonna address
violation.
violation because
Yes, Your
you made a
Honor.
call
You've been
and they're
contacting the
describing all
jail
this
calls on our
allegedly.
records. We have 17 complete calls to the victim since he was arraigned, as well as 84 total attempt in tries. So he's tried to call her a total of 84 times, with 17 of those calls getting through.
Counsel.
Your Honor, this
The
is,
bond violations. Why don't we start there?
Your Honor, this is, I didn't have enough time to talk to him about the particular alleged bond violation, Judge. I did read it yesterday. It was sent to me and I did read the bond violation.
And does he want it set for hearing? Or?
One
does
second,
he
Judge.
admit to the violations? Gonna need a,
Okay. This way. Do you want to send it for hearing? Yes, Judge.
what are we gonna do?
It's just to set it for a hearing, Judge. I'm assuming it's another day.
Yes,
Okay.
set a bond violation hearing. Gonna have room on 12th.
Yes.
So I'll adjourn the probable cause and set a bond violation hearing for June 12th, 2025
Split second,
at
Judge.
3 p.m.
I'm here.
Pending that hearing, defendant.
I'm here, Judge. I'm here in front of this court that same day.
All right.
So
So that's at 3 p.m. And pending that hearing, defendant's phone privileges are hereby ordered revoked. his bond, however, is continued. Thank you.
So Judge will set an exam day on that day.
That is where.
Thank you.
Court calls case People versus Derek Stewart.
APA Rachel McDuffie for the people.
Mr. Derek Stewart,
The public defender case. No one was assigned to it.
No one responded.
I'm here, Assistant Public Defender Jay Bellinger, on behalf of Mr. Stewart, it sounds like. Derek Stewart.
He's here.
Okay. Thank you. And Your Honor, obviously, we haven't, our office has not had any time to review his police report with him and the evidence, so I
Well, what is this say? Except for confidence.
It's just on the bond.
It's here on the bond, on the bond, right? And you know nothing about those, I take it.
That's correct, Your Honor.
Is there a report? Oh,
That's all.
counsel.
what?
When justice moves slowly, it's not mercy, it's exhaustion. Systems stall, people fade, memories blur. But for those waiting on the outcome, every delay feels like punishment without a sentence.
Okay, on this matter, the defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been in. I think at this point, he's being held on this alleged bond violation, because otherwise it wouldn't have occurred anyway. So at this point, what I will do is I'll continue the defendant's bond as being revoked for the violation pending a hearing on this. There's a report that needs to be prepared, as well as I have shown counsel the preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025 at 3 p.m.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Anton Brooks.
Good morning, Your Honor. Wendy Barnwell, standing in for the attorney of record, Mr. Kareem Johnson, on behalf of Mr. Brooks.
Thank you, sir.
Anton Brooks.
Do you have any Barnwell certificate?
Yes.
All right, what are we doing?
Your Honor, Mr. Johnson needs an in-person PCC on June 26th. He told me that's when he's available. He said, however, because he doesn't have all
Go ahead. I'm listening.
all the discovery.
Oh, hold on a second. So he doesn't have the discovery. The 26th, he's just asking for an adjournment of the probable cause
PCC,
conference.
Judge.
Okay, thank you. Probable cause conference will be then adjourned on January 26, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you. Court does call the case People versus Robert Brascom. Brascom.
Marie Canhouse is the prosecuting attorney on behalf of the people.
Good morning. This is Public Defender Lauren Penny on behalf of Mr. Branscombe. Mr. Branscombe, please state your name for the record.
Robert Branscombe.
Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
I believe so, Your Honor.
Preliminary examination in person, June 17th, 2025 at
12 p.m.
12 p.m. That's before me.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued.
All right, thank you.
Thank you. Court does call the case People versus Anthony Alfaro Siquejas.
Thank you, Richard McDifford.
Your Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Alfredo Correjas.
There yet. They had the wrong call. Seriously? Not there.
You can state your name for the record. Anthony Alfaro Correjas.
Got it. All right.
At this time, Your Honor, I'll be asking for a brief adjournment. He has another probable cause conference date scheduled with you next week on a new matter that is the basis for the alleged bond violation. So we are asking for the adjournment to be able to track those cases together.
He has a what?
A probable cause conference with you on June 12th.
On June 12th.
So next week. So we're just asking for that brief adjournment so the cases can track together.
And that case is what result. Oh,
Is what I believe is the alleged bond violation.
that's what I was trying to follow with what you indicated. So we'll
Yes, sir.
deal with that bond violation. I'll grant the adjournment.
Thank you, Your Honor.
I'll adjourn this probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Mr. Bukovich, that went much better for you than last week.
It did.
Maybe it can continue.
That's the goal, Your Honor.
Because when you came up, I got scared. I just didn't know. Court calls the case, People versus London Daughter.
Andrew Childers appearing on behalf of the people, Your Honor.
Gentleman's addition on behalf of Mr. Daughtery.
London daughter. Okay. It's two cases. What are you looking to do?
Your Honor, we are going to be adjourning. I believe we don't have discovery on one of the cases. So we're waiting to receive that from the prosecutor's office.
And I'm presuming that's on its way.
This isn't just about law. It's about power. Who holds it, who hides behind it, and who's crushed beneath it. Every sentence spoken here has weight, measured not in words, but in consequences.
I believe it's the 1318, or one of the legal assistants or paralegals in our office emailed, I believe Tuesday, and then they looped you in and said, have you guys requested it? It's from a couple of years back, but we don't have discovery on one of them.
All right. Well, what I'll do is I'll adjourn probable cause conference June 26, 2025, 9 a.m. Let you guys try to get that cleared up. I see that the one is a 22 case, so sure they'll be able to find it. But all right.
Thank you.
We'll continue. Thank you, sir.
Thank you. Okay.
Court calls case People versus Jerome Burns.
Morning, Honor. And Assistant Prosecuting Attorney Beth.
And Assistant Public Defender Chinazi Kyriak and really you're on behalf of Mr. Jerome Burns.
Nice of you to show up. Just thought I'd throw that out there.
I figured it was coming your way.
Mr. Burns, state your name for the record, please.
Jerome Burns.
Thank you, sir. All right, what are we doing?
So, Your Honor, we are here for two matters today. I think we're doing a sentencing on the bond violation for Mr. Burns, as well as the probable cause conference. In regards to the probable cause conference, Judge, we are asking that this matter be respectfully set for preliminary examination.
You have all of the discovery.
To my knowledge, Judge, yes, we do.
We'll have the witnesses available to 7.
We'll do our best here.
All right, why don't I do this? I'll set preliminary examination June 17th, 2009, 9 a.m. Or, well, why don't I do it this way? I'm going to set this one at 12 p.m. for me since I just plea on the other day. And I'll adjourn the sentencing on his bond violation to that same day.
Okay.
Thank you.
So, bond will continue. Court does call the case People versus Tequila. Evans, Guy. What?
She should be on Zoom.
Tequila's on Zoom? Is she here?
Oh, okay.
I don't see her name. Oh, there she is. Tequila, stop coming down.
She wished she could have.
Sure. Tequila, can you state your name?
Tequila Evans Guy.
Good morning.
Good morning.
What are we doing?
So, Your Honor, when we were here last time, I incorrectly filled out the plea form where I said that I was adding count 2 and dismissing count 1. And I meant to put I was adding count 3 and dismissing count 1 and 2. So that is why you're here today.
It's also my bad because I didn't notice that on the plea form. So it's count 1 and 2 that are getting dismissed.
Got it. We're coming back just to correct the record. All right. what I will do then is I will sign sort of dismissing counts 1 and 2, accepting the defendant's plea to count 3, and then set the sentencing date. I'll set the sentencing date 7/10/25 at 10 a.m. before Judge Washington. And what I will do is I'm accepting the plea to count 3, non-protunct to May 22nd.
Do we need to turn in the form or not? The correct
Yes, why
report?
don't you?
We don't need the advice of rights again, right?
You don't need that.
Okay. Thank you, Your Honor. Thank you, John.
Thank you. That should clarify everything. Court calls case People versus Curtis Damon.
Good morning, Your Honor. Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Damon.
Good morning, Ms. Sharpie.
Good morning. Mr. Damon, could you state your name to the court?
Yes, Curtis Mitchell Damon.
Your Honor, I did fill out a green sheet. However, I am asking if this court would consider allowing Mr. Damon to be released to treatment. He is
To inpatient treatment?
to inpatient.
I'm going to have no objection to any order allowing somebody to release.
Okay, thank you, Your Honor. I think that will help immensely, and I know Mr. Damon is really serious about that.
All right.
Oh, and we would request an adjournment of the probable cause conference for him to get into treatment. I think that will help discussions with the prosecution about how to
Do
resolve.
they have a timing to try to get him there, or how's?
I don't have any specific update as to timing.
Well, why don't I do this, then I'll adjourn the probable cause conference to June 26, 2025, 9 a.m.
Thank you.
See what progress they make regarding.
Thank you, Your Honor.
Thank you.
My quick question regarding bond, because Mr. Damon's tether, I mean, they closed his file essentially because he absconded as far as his frame is concerned. What would be the status of that order? Would the court wait to see if
They closed it, they closed out his tether.
Yeah, we have a report from May 13th, I believe, where they had lost contact with Mr. Damon. He last reported for a scram download April 29th. And so where that particular tether might be located and whether we would need a new order, depending on what happens with his treatment. He said he still has it.
And thank you, Ms. McDuffie, for bringing that up, because I actually, in the proposed order I drafted, I did put in all prior bond conditions remain in full force and effect. I didn't mention anything about the tether, so.
Okay, I'm just looking at it. That was a GPS tether.
Correct.
No, alcohol.
It was a scram tether?
Yes.
Yep.
Okay.
Yeah.
So what I'm gonna do is I'll just add it, I'm adding a sentence to the order I signed. He can be released to inpatient treatment program once a bed becomes available with a scram tether prior to release. Okay, so I'll add that, and I will also sign a new order for a scram tether. So that way, if a bed becomes available, he gets a scram tether. Okay,
Thank you, Your Honor.
and I'll set it for June 26, 2025, and bound continue. Thank
you. Thank you.
Court calls case People versus Toronto Francis.
After letting people,
Suze? Seriously? Okay.
Oh, it's Francis. Oh, Assistant Public Defender. I thought they were bringing up my other client, Judge. Assistant Public Defender, Chinati Kerry, I can really, on behalf of Mr. Brown, to Francis, Judge. Can we approach?
Durant to Francis.
Thank you.